They and another Appellants and the Governor of the Cayman Islands and another Respondents, Cayman Islands.
Lord Sales will hand down at this opinion.
This is an appeal from the Cayman Islands. The point in issue is whether the Constitution of the Cayman Islands confers a constitutional right to legal recognition of same-sex marriages, which cannot be abrogated by the legislature. This depends upon the interpretation of the provisions of the Bill of Rights set out in the Constitution. The appellants are two women who are in a committed relationship and wish to enter into a same-sex marriage recognised in law. In 2018, they were refused a licence to marry on the grounds that the marriage law in the Cayman Islands defines marriage as the union between a man and a woman as husband and wife. The appellant started legal proceedings claiming that the marriage law, which is ordinary legislation, was incompatible with their constitutional rights set out in the Bill of Rights. The constitutional rights set out in the Bill of Rights are binding as against the legislature in the Cayman Islands and have legal force superior to that of ordinary legislation. The Bill of Rights is modelled on the scheme and the provisions of the European Convention on Human Rights, which is also applicable to the Cayman Islands. The Bill of Rights contains provisions for protection of private and family life, which is Section 9, for conscience and religion, which is Section 10, and against discrimination, which is Section 16. All of these are equivalent to provisions in the European Convention. But for present purposes, the most important provision of the Bill of Rights is Section 14, which specifically deals with the topic of marriage in the same way that Article 12 of the European Convention specifically deals with that topic. Article 12 creates a right limited to opposite-sex marriage. Section 14 of the Bill of Rights states that government shall respect the right of every unmarried man and woman of marriageable age freely to marry a person of the opposite sex. It is very clear that the appellants can have no right to marry according to this provision, but despite this, they say that the other provisions of the Bill of Rights should be interpreted in an expansive way so as to create a constitutional right for same-sex marriage by implication. The appellant's claim was successful at first instance in the Grand Court of the Cayman Islands, but the Cayman Islands Court of Appeal allowed an appeal by the island's government. The Court of Appeal held that it was not possible to find a right for same-sex marriage in the other provisions of the Bill of Rights. The appellants now appeal to the Judicial Committee. The Judicial Committee would unanimously dismiss the appeal and will advise Her Majesty accordingly. In the context of the Bill of Rights, Section 14 is the provision which specifically deals with marriage. The right in Section 14 is confined to opposite-sex couples. Where a legal instrument contains a specific provision which deals directly with a particular topic, other general provisions in the instrument have to be interpreted in the light of that. They cannot be given a meaning which undermines what is set out in the specific provision. For this fundamental reason, the Judicial Committee has concluded that the other general provisions set out in Sections 9, 10, and 16 of the Bill of Rights cannot be interpreted so as to create a right for same-sex marriage, when that is so clearly excluded by the terms of Section 14, which is the specific provision dealing with the topic of marriage. This reasoning is essentially the same as that adopted by the European Court of Human Rights in relation to the same issue when it has arisen under the European Convention. The European Court has held that because Article 12 is the provision in the Convention which specifically deals with the right of marriage, and it is limited to a right for opposite-sex marriage, the general provisions on family and private life and so forth in the European Convention cannot be interpreted expansively so as to create a right for same-sex marriage by a sidewind. Rather than a right of marriage, the European Court has held that the right to respect for family and private life creates a right for same-sex couples to seek other forms of legal recognition for their relationships. The Cayman Islands government accepts that the equivalent provision in the Bill of Rights has the same effect. Accordingly, a form of civil partnership recognised in law is available for same-sex couples in the Cayman Islands, and there is constitutional protection for this. Finally, the Judicial Committee points out that the Bill of Rights does not prevent the Cayman Islands Legislative Assembly from introducing legislation to recognise same-sex marriage. But this is a matter of choice for the Legislative Assembly rather than a right laid down in the Constitution.